Alright, let's go ahead and begin week 4. This week's topic is federalism. This week is just a little bit different because I'm teaching federalism for both my American government and my Texas government course, whichever one you guys are in. This is going to be the same lecture for both of my classes. And the reason why is because federalism is a topic that touches both American government, federal government, as well as Texas government as well. And you're going to see exactly how that plays out. So it's very important to the national government, Texas government as well. Which is kind of why I have this picture here of both the American flag and the Texas flag. And federalism really kind of embodies how both the national government and the Texas government kind of interact with one another. So let's go ahead and begin and talk about different structures of government. All nations, all different countries within the world have at least one of these structures of government. They either have a confederation system, a unitary system, or a system of federalism in place. And here in the United States, we have a system of federalism, particularly under this current Constitution. The first one here is a confederation system. A confederation system is just where you have one nation. You have a nation, a country, that has a lot of different regional or state governments. And they give all the power to the state governments, or the regional governments. So states have most of the authority, and this happened in the United States under the Articles of Confederation. Under the Articles of Confederation, you had you had a national government, but the national government was very, very weak, and the Articles of Confederation gave all the power to the state governments. Now for my federal government course, we talked about this last week when we talked about the Articles of Confederation. And for my Texas government course, the Confederation system is very important because Texas was once part of the Confederate system here in the United States. Now, Confederation systems are very rare, and they often are very unsuccessful because there's a lot of chaos, and there's a lot of uncoordination. There's a lack of coordination, I guess I should say, between the state governments. There's also a unitary system, and a lot of nations actually do have a unitary system. And a unitary system just means that the majority of authority is within the control of the national government. Examples of this would be Indonesia, the United Kingdom, France, Italy, and Japan. Now, while you may have states, you don't really tend to have state governments under unitary systems. Instead, you just have one national government that kind of oversees everything that goes on. Parliamentary system tends to be unitary. So if you see a state if you see a country or a nation that has a unitary system or if it has a parliamentary system, they tend to be unitary, meaning they only have one national government that oversees everything that goes on. You may also have a lot of local governments, but really the national government is the one that oversees everything. Now, when you combine a confederation system with a unitary system, you get a system of federalism. And this is what we have here in the United States. We do have state governments, but we also have a national government. And a system of federalism, by definition, is just a system of government that divides power between nations and states. Both have concurrent and separate jurisdiction. And what that means is that you have a national government with a certain amount of power, and then you also have a state government that has a certain amount of power as well. This federal and state division of power under this system of federalism allows for specific powers to be granted to each level of government. Each level of government has certain powers that it carries out. And we're going to go ahead and talk about those later on in the lecture. In fact, we're going to talk a lot about what powers are delegated to each level of government. Both the federal and state can limit the powers each can claim. If the federal government thinks that the state governments are doing something that's unconstitutional or against their interests, they can step in and limit the power of the states. But if the state governments kind of group together and say the federal government is overreaching its bounds, they can step in and limit the powers of the national government as well. This is thought to protect minority, non-majority. It's thought to protect the minority from the majority, because states can retain powers over their own people. If the state believes that something that their people need or something like that, the states can claim to have power over its people and provide for its people. And even if their group of people may be in the minority at large on a national level, they're still citizens of the state that the state can step in and help them out. Now, this allows states to specialize in needs specific to their population. And what I mean by that is that is that the states can go ahead and cater to the needs specific to their population if their population supports a certain political issue or a certain program in general. This is what's basically kind of the concept of laboratories of democracy. And laboratories of democracy was a term branded by Justice Louis Brandeis. Justice Louis Brandeis came up with this idea of laboratories of democracy. And what he meant by that is that states are laboratories of democracies in the sense that states can experiment with new policies and they can experiment with new ideas. And if those new ideas succeed in the states, well, then other states can look at that state and say, hey, that's really successful. Maybe we should try that as well. An example of this would be Colorado and Washington, where Colorado and Washington are both experimenting with legalized recreational marijuana, and then Oregon and Alaska kind of looked at that. And most recently, in the 2014 election, Alaska and Oregon went ahead and legalized recreational marijuana also. So the Colorado and Washington experiment in the laboratory of democracy within their own state led to other states experimenting with it as well and expanding on those ideas. The federal-state division of powers is also thought to increase participation because of emphasis on smaller groups. More people will participate in the political system because states are a smaller entity, and people within states. States are more responsible to the people, is what I'm trying to say here. States are more responsible to the people, and this concentration on smaller groups will allow citizens to influence their state government, which then can influence the federal government as well. It encourages this marketplace of experimentation and innovation if governments compete. Like I said, kind of going back to the laboratory of democracy thing, if state governments are being innovative, trying new policies, and they're working, and the experiments are working, then this marketplace of ideas, this free flow exchange of ideas between states, really makes progress within the really encourages progress within the United States. This is how federalism breaks down in the United States. So federalism is this idea that we have overarching federal government, and then we also have state governments below it. But below the state governments, on this kind of tier here, we also have county and municipal governments as well. Townships and school districts as well, I guess I should say. So you have one overarching national government, but then you also have 50 state governments. And then below the state governments, you have 3,033 county governments as of 2008, and you also have 19,492 municipal governments as of 2008. I'm sure these numbers have changed just slightly, but the two numbers that haven't changed are we still have one national government and we still have 50 state governments. They can guarantee there will be a question on your test about how many state governments there are. I hope you know as U.S. citizens that there are 50 states within the United States. So that will be a question: how many state governments are there? But it's important to realize, even though when especially today, we're going to talk about just the national government and the state governments, but it's also important to note that underlying that principle is a lot of other miniature, smaller governments overseeing or governing as well. So this is kind of how the breakdown of the governments go in the United States, and these all make up the system of federalism, from the very smallest to the overarching top here. It's also kind of I also want to bring up here that it's also kind of a paradox that we have so many local governments, so many smaller governments that a lot of people don't participate in. A lot of people don't tend to participate in these municipal governments, even though there's so many, and they're so close to us. They resonate. Their laws make a lot of personal impacts on our lives, but a lot of people don't participate in those sorts of elections for these types of offices. Instead, a lot of people turn out for this one here, often the presidential election, or at least the midterm elections for congressmen and senators and things like that. So even though these smaller governments are the ones that are more personal to us and make the laws that impact our lives more people tend to focus on this, and this is probably just because it's easier. There's only one of them. There's only one of them to concentrate on, so it's easier for us to pay attention to what's going on in that one government rather than these smaller town governments, local governments, I guess I should say. All right. So this is how this is called what's called the vertical separation of powers. This means that the powers on top and the powers below, and the powers on top tend to be the federal government. So this vertical separation is just basically the division of powers between the federal and the state governments. Let's go ahead and tackle the federal government first. The federal government is over here on the left-hand column. The federal government it's obviously the national government. The national government has limited powers to promote national unity. It is the goal of the federal government to promote unity among the states because the states end up making the federal government. The federal government has certain powers to promote national unity, and these powers are outlined in Article 1, Section 8. It is expressly written in the Constitution what exact powers the federal government has. And more specifically, the Constitution outlines what powers Congress has, because Congress is seen as an embodiment of the people, as an embodiment of the states. The writers of the Constitution, the founding fathers, wrote into the Constitution what powers the federal government has, and they wrote it specifically into Article 1. Now, for my American government course students, if you remember from last week's lecture, that Article 1 is the one that deals with the legislative branch. And so the reason why the founders put it into Article 1 is, once again, because Congress is an embodiment of the people, so therefore it's the foundation of the federal government. So they put it in Article 1, Section 8. The federal government has the power to tax and spend. They also have the power to promote interstate commerce. And then on this third one, necessary and proper. They have the power to do what is necessary and proper to ensure the welfare of the nation, or ensure the good of the nation. Now, what is exactly necessary and proper for the good of the nation? Well, that's up to interpretation, and a lot of lawsuits against the national government tend to go against this necessary and proper clause because it's sort of wishy-washy term. It's sort of just a term they threw in there to kind of cover their bases. And so it's also often deemed the implied power. It's just implied. It's not expressly written. It's not expressly written what exactly necessary and proper means, but it's in the Constitution. So these are the three powers of the federal government that are written within the Constitution. And years later, we added a fourth power for the federal government to exercise, and that's the 14th Amendment. The 14th Amendment is a power that I'm going to talk about on the next slide. The 14th Amendment is a power that allows states to prevent discrimination, allows the federal government to prevent states from discriminating against its own people. Because at the time when the 14th Amendment was passed, it was just right after the Civil War. The federal government was really worried that everything that they fought for the Civil War was just going to be thrown away because the South was going to end up discriminating against its own citizens, particularly those that were just freed from slavery. And in many ways they were right, and in many ways the 14th Amendment covered their bases. But we're going to go ahead and talk about that here in just a little bit. So the federal government has these three powers, and I care that you know this for your test. The three powers are the taxing and spending clause, the commerce clause, and the necessary and proper clause. Those are the three that are written in the Constitution. And then nearly a century later, we added the 14th Amendment, which gave them a fourth power. What's really important for the federal government powers is this Article 6, which is the Supremacy Clause. And you can go ahead and click on this link and read the Supremacy Clause if you want. But Article 6, particularly for my federal government students that are listening to this lecture, if you remember from last week's lecture, we talked just briefly about Article 6. But Article 6 is basically the part of the Constitution that says the federal law is the supreme law of the land. Whatever the federal law is the one that should be interpreted the closest. It is overarching over state laws. Now, that doesn't mean that state laws don't matter. It just means that the state governments cannot pass laws that inherently contradict federal law. They can't purposely contradict federal law because in a court of law or in the courts, the federal law will uphold or be held supreme over the state laws. Now, that helps out the federal government quite a bit, but it also doesn't give them absolute power by any means. So let's move over here to the states. Over here on the right-hand column, you have the states, and the state governments can retain the remainder of the power not allocated to the national government. So any powers that are not listed in these three, or this one here, the fourth one, the state governments have control over that. The state governments retain the remainder of the power not allocated in the national government that are not expressly written in the Constitution. And this is exactly why these federal government powers here are often called express powers, but we're going to go ahead and address that just a little bit later. The Bill of Rights was really the part of the Constitution that really aimed to help out states. The Anti-Federalists at the time of the founding were really concerned that the states did not have enough rights. So the Anti-Federalists wanted the Bill of Rights included. The Bill of Rights really limits federal authority. Remember, Anti-Federalists were against federal authority. The Anti-Federalists included the Bill of Rights, and the Bill of Rights limits the federal authority from interfering with states' rights. And this comes from the 10th Amendment. And if you want to go ahead and click on this link on the 10th Amendment, I would really encourage it just to at least read a little bit about the 10th Amendment. But the 10th Amendment says that powers that are not written in the Constitution are reserved to the states or to the citizens of the United States or to the people. And so this is really important for states such as Texas, and especially for my Texas government students listening to this lecture. The 10th Amendment is essential for Texas to be able to govern its people and to function as a state independent of the federal government. There's several interesting links down here if you want to click on them, being in my Texas government course or just a Texas citizen in general. There's an article about Texas sovereignty and how Texas has this tradition of being a sovereign nation, and so therefore really exercises its 10th Amendment rights more than most states. You can also see a very interesting debate about states' rights versus federal government in Jon Stewart versus Rick Perry. Definitely an interesting watch if you do have time. But this is the vertical separation of powers. It's the idea that you have a division of power between the federal and state governments. And we're going to go ahead and talk a little bit more about each of these powers, and we're going to talk about them in terms of just federal government powers only, powers that the federal and state governments share, and then powers that only the state governments have. But I want to go ahead first and address a little bit more about this 14th Amendment. The 14th Amendment, at the time it was passed, was very, very interesting because it's the only amendment, and was the only amendment, that gave the federal government more power than it had previously. So other federal powers is the 14th Amendment, Section 5. The 14th Amendment was established right after the Civil War, and it limits states from discriminating against their own citizens. It provides equal protection for all citizens, including those that were freed slaves. It requires that states provide due process to all citizens to prevent arbitrary treatment. Section 5 specifically is the one that gives the power of the Congress to do this. Section 5, 14th Amendment, Section 5 was the very first time that we'd added more powers to Congress or to the federal government. It states that the Congress shall have power to enforce by appropriate legislation the provisions of this article. Now, this was very important because it was giving Congress a new power, and it was giving them the power specifically to kind of impede on the states a little bit, to enforce the law or enforce equal protection of the law to all citizens, regardless of what state they're in. After the Civil War, the 14th Amendment was designed to limit what states could do to their own citizens. An interpretation of this law is complicated because there's a lot of things that could be considered discriminatory or arbitrary, and so that's kind of up to interpretation. But for the most part, it's much more of a civil rights issue. It's important to have this 14th Amendment here to at least guarantee some civil rights. And we're definitely going to address civil rights when I think it's towards the end of the semester. But for both my Texas government courses, and my American government course, we're both going to talk about civil rights and civil liberties and how that impacts you as a citizen. But just know that for now, in terms of federalism, the 14th Amendment was the very first amendment to give Congress more power than it had previously, and so therefore kind of shifted the dynamic between federal and state governments at the time. Alright, so we're going to go ahead and talk about each of the different powers that the federal government has. So first we're going to address federal government powers only, then we're going to address federal and state government powers, then we're going to address state-only powers. And we're going to go through each of the federal government powers. Going back a couple slides, you remember that the federal government has the Necessary and Proper Clause, the Taxing and Spending, and the Interstate Commerce Clause. Let's deal first with the Necessary and Proper Clause. This was the main Supreme Court case that established the Necessary and Proper Clause for the federal government. It was McCulloch versus Maryland, and as you can see, this happened in 1818. So it happened very early in the founding of our nation. We were just kind of starting to form our identity as a nation. And McCulloch and Maryland really solidified the powers of the federal government. So in McCulloch versus Maryland, you have the federal government that wants to establish a national bank. The Federalists at the time, remember, the Federalists are the ones that tend to promote national government. They want more national government, and they tend to favor more federal government. The Federalists at the time see that we should establish a national bank. The national bank will allow us to save our revenue, will allow us to generate revenue in terms of loans and things like that, and also provide a stable amount of money that we can have. So it's good for the nation. It's a win-win. It helps us economically. Well, unfortunately, the Anti-Federalists see this as an as the national government imposing too much power. The national bank was under control of the Federalist Party, obviously, but it was really unpopular in the West and South. Remember, the West and South was primarily Anti-Federalist at the time, including Maryland. Maryland was considered part of the South. I wouldn't consider it part of the South today, personally, but Maryland was considered part of the South then, and they tended to be Anti-Federalist, and therefore they were against this national bank. They thought that it expanded the powers of the national government way too much. So what Maryland did, they looked at this national bank and said, hey, national bank, you're on our soil. Therefore, you owe taxes to us. So Maryland imposed these really stiff taxes on the bank operations. The bank refused. The bank said, no, Maryland, you're just a state. We're a national entity. We're above you. Remember the Supremacy Clause? We're above you. We're supreme. We don't need to pay your taxes. Well, this kind of made Maryland really mad, and they brought a suit against I believe he was the treasurer of the secretary at the time, McCulloch. They bring this suit against him. And the question that is imposed to the Supreme Court is basically, one, does the federal government have the power to charter a national bank? And then two, do the states have the power to tax such banks? Well, for question one, does the federal government have the power to charter a national bank? The answer is yes. The federal government can, because a national bank is necessary for our national interest. It's necessary for the government to function. It's necessary to raise revenues. It's necessary to have a money supply. It's necessary to conduct business. Do the states have the power to tax such banks? The Supreme Court said no. States cannot tax national government interests, cannot tax national government entities either. And the reasoning is that the government does have the power to establish a national bank to pursue the necessary and proper clause. Banks are necessary and proper. And states cannot discriminate based on trade, and the power to tax is the power to destroy. So the argument here is basically that if you tax a national bank so much, it'll collapse. And therefore, it'll destroy the national government. And then we're going to end up right back where we were with the Articles of Confederation. Now, this had serious implications at the time. If states were allowed to tax these national banks, you could say that there would be no national bank today. So therefore, any of you that have Bank of America, that wouldn't exist today. There would be no Bank of America. If states are allowed to tax banks to death, it destroys national interest, therefore it destroys the federal government, and then we end up right back where we were. So McCulloch and Maryland really established the necessary and proper clause. It established what was necessary for the government to do in order to function, and if states try to interfere with that or anyone else tries to interfere with that, they are beyond their legal means. And so this gave federal government more power, and it gave them the necessary and proper clause. So that's the example of the necessary and proper clause. Let's go ahead and talk a little bit about taxing and spending. Now, the federal government, according to the Constitution, can tax and spend for the general welfare, meaning anything that benefits the nation. The House originates all revenue bills. Anything that deals with money is originated in the House. And that's why it's always interesting when you hear people being critical of any president that raises taxes or any president that has an unbalanced budget or anything like that. It's very interesting because it's not really the president that does that. It's the House. The House of Representatives is the one that originates all revenue bills. Now, it's complicated because 3/4 of the federal aid dollars goes to highway, welfare, and health, which are traditionally state issues. So taxing and spending can be very tricky sometimes because the money tends to go towards the states, even though the states should be raising their own revenue. So you can see how taxing and spending is kind of a complicated issue. 20% of state revenues come from the federal government. Keep that in mind when you answer your discussion board question this week. There's a question about Texas and whether it can survive without the United States. Keep in mind that 20% of state revenues come from the federal government. So taxing and spending is very important to the federal government, but it's also very important to the states because the states rely on that so much. Yeah, a little bit about individual income tax. Individual income tax was not allowed under Article 1, Section 2 in the original Constitution, but it was changed by the 16th Amendment. The 16th Amendment granted the United States, granted the federal government the power to raise individual income tax. So it didn't really grant them a new power necessarily. It didn't grant them, it kind of held up under the taxing and spending clause. Unlike the 14th Amendment, which granted them a brand new power, the 16th Amendment allowed them to continue on, or to continue a new form of taxing and spending, essentially. We'll go ahead and talk just a little bit about a brief Supreme Court case that dealt with taxing and spending. This is South Dakota versus Dole. South Dakota versus Dole was not essential to the taxing and spending clause, and it certainly wasn't the first Supreme Court case to deal with taxing and spending in any way. But it's still very unique, and it's still very interesting to talk about, and I usually like talking a lot about it with college students because it deals specifically with drinking, which is a fun pastime of most college students. I know I partook when I was in college quite a bit. That being said, South Dakota versus Dole happened in 1987, and what happened in the 1980s was the federal government wanted to raise its drinking age from 18 to 27. So in the 1960s, 1970s, when you were going to college, I know my dad went to college in the early 70s, when he was in the late, I guess he was the early 70s. When he was in college in the early 70s, the drinking age was 18. So as soon as you arrived at college, you could start partying and start drinking. Well, the federal government wanted to raise the drinking age. Well, the states didn't really like that. The states said, no, it's up to us to raise the drinking age. And Congress says, okay, playing a little bit of politics here. Congress says, okay, if you don't want to raise it to 21, we just won't give you any money for the federal highways. For any federal highway programs, you don't get that money. And South Dakota was one of the states that held out for a really long time, along with Louisiana. I don't know if any of you have been to Louisiana, but Louisiana has terrible roads because Louisiana didn't raise its drinking age until, I believe, in the early 2000s. So therefore, Louisiana was missing out on these federal highway monies. They weren't getting this money to improve their roads, and so Louisiana roads are terrible. South Dakota gave in a lot sooner, we'll just say that much. So Congress wanted to get states to raise the drinking age from 18 to 21, and they did so by withholding federal highway program money. South Dakota said, this is unfair, you can't withhold this money for us, and so they took it to the Supreme Court. The issue here is, can Congress withhold money from the states in order to get them to raise their drinking age? And the answer is yes. They can withhold the money in order to get them to raise their drinking age. And the holding is that Congress is only indirectly getting the states to do what it wants. It's not being coercive. It's not knocking on their doorsteps telling them to do it now. It's just saying, they're just playing a little political game, a little hardball. If states want to keep their drinking ages, they can. They can reject the federal money. They just won't get any more federal money, which was very difficult for states to maintain roads if they're not getting money to do so. So what's more important, the drinking age at 18 or having nice roads? And most states liked having nice roads, so they gave in and raised the drinking age. So I'm sure there's certain health issues behind the drinking age as well, but really when you look at why the drinking age is 21 now, it's because states wanted new roads. They wanted nice roads to have. And so South Dakota versus Dole is the Supreme Court case that addresses that. And just shows how the federal government can use taxing and spending to influence what states can do. And it's within their means to do so. So that's taxing and spending. Let's go ahead and talk about the Commerce Clause. This is the Supreme Court case that really upholds the Commerce Clause. And it's Gibbons versus Ogden. This is in 1824. So this is one of the very first ones to deal with the Commerce Clause, and it's very important to how the Commerce Clause functions today. Back in the 1820s, you had New York. New York was its own state, and they gave licenses to ships that traveled in its waters. So if you were a New York ship and you were traveling in New York waters, you had this license, and you were free to travel as you wish. However, if you were a company from out of state, if you were a ship from out of state, you were charged a fee because you didn't have this license that said you were from New York. You were charged a fee in order to use the waters around New York State. Well, this seems kind of discriminatory towards other states, and particularly against ships from other states. And the federal government steps in and says, hey, New York, you're being unfair to other states. You're being unfair, you're not helping out interstate commerce. Remember, because it's one ship from another state into another state, so therefore it's interstate commerce. The federal government says this is interstate commerce. And the federal government claims that it has the power to regulate this commerce, particularly because it has the power to regulate, word for word from the Constitution, it has the power to regulate commerce with foreign nations and among several states and with the Indian tribes. So the issue here is, must a boat ferry that operated between New York and New Jersey pay fees to New York State? The answer is no. The federal government has the right to regulate this and can abolish all fees that are paid. Now, this doesn't mean you don't need certain licenses to drive a boat and so forth, but if you're a boat trying to ship a product from New Jersey into New York, you shouldn't have to pay a fee. All interstate commerce should be free, and states should be able to engage in commerce with one another. The holding is that the federal government retains the ability to regulate commerce between the states, and New York State cannot charge fees. So this really established that this was one of the very first cases that established that the federal government could regulate commerce between the states, and has continued to do so, up until the present day, for centuries almost now. They've been able to regulate interstate commerce. Gibbons versus Ogden, I can guarantee there'll be a question on your test, so be sure to review that just a little bit. Just note that this is the one that established the Commerce Clause. Federal government may also have interest in interstate commerce as well. So while Gibbons versus Ogden established interstate commerce and federal government interest, or federal government's power to intervene in interstate commerce, there's also times where federal government can intervene in interstate commerce as well. The federal government may regulate interstate commerce, particularly if there's a national interest at hand. I have just a few examples here. You have the food industry. The food industry is very important to national interest because having a sustainable food supply or a good food supply for your citizens is important. You don't want your citizens to go hungry, so therefore it's a national interest. Agriculture is much along the same lines. Energy is becoming a federal interest as well, because having energy to fuel your economy is very important, particularly, and then also with sustainable energy, it's becoming a federal interest as well, because we need to have renewable resources to continue our lifestyles and continue the energy consumption that we're currently undergoing. So also travel and hotels. Travel and attractions are seen as an important part of the economy, and so therefore the federal government has an interest in that as well. So these are all interstate. They're not moving from one state to another. They're staying within, say, Texas, or they're staying within a particular state. They're not moving anywhere. But because there's a national interest at hand, a federal interest at hand, the federal government is allowed to step in, and they often are allowed. The Supreme Court has often upheld their right to do so because of the national interest at hand. And so therefore, not only is it under the Commerce Clause, it's also necessary and proper to ensure the future of the nation as well. So, hope that made sense. Let's go ahead and talk just a little bit about powers that states and the federal government share. Now, this is with the federal. We just talked about powers that are only for the federal government. Let's go ahead and talk about the powers that they share, and these are called concurrent powers because they're shared between two states or between two governments. Taxing. Both the federal and the state governments engage in taxing. The reason why is because taxing is important to raise revenues for your state. If you want to pay for the programs and the roads and the infrastructure and things like that, taxing is very important. So the federal government engages in a certain amount of tax revenue in terms of state taxes, income taxes, payroll taxes, things like that. But so does Texas. Texas doesn't have an income tax, but Texas also has property tax, sales tax, and things like that. Both the federal government and the state government set up courts. Both the federal government and state governments build highways. You should often look whether you're traveling on a U.S. highway or a state highway. That determines who's building that highway or who's maintaining that highway as well. Borrowing money is very important to both states. Making money and enforcing laws is very important. Obviously, federal law versus state law. Prosecuting criminals, chartering banks and corporations. There's national banks and then there's state banks. So be sure, depending on what bank you have, you probably know whether it's a state bank or a national bank. Spending money for the betterment of the general welfare. Both governments have interest in doing that to promote the general welfare. Taking and condemning private property with just compensation, which is also called eminent domain. If you have some free time, I would definitely research just a little bit on eminent domain. It's very fascinating. But both the federal government and the state governments can take your private property as long as they show to the court that they provided you with just compensation. Eminent domain is a very fascinating topic, especially if you're going into law or maybe some legal studies. I would definitely look into eminent domain. It's very, very fascinating. So those are concurrent powers. What about reserve powers? What are powers that only the state can do? These are called reserve powers because only the state can do them. I have several examples here. Property and contract law. Anything that deals with property and contract law is only the state's business. Only the states can handle property and contract law. Interestingly enough, establishing local governments. Local governments do not exist without the state governments. We're going to talk about local governments, I believe, on the next slide here. But it's very interesting that local governments do not exist in the American Constitution. The federal government has nothing to do with local governments. Local governments are solely responsible to the state. And the idea here is that the local governments are responsible to the state, which are responsible to then the states are responsible to the federal government, so it ensures the structure of federalism can continue. Criminal law. States only deal with criminal law. Anytime you break a law and you're committing a crime, you are responsible only to the state. Most federal lawsuits are part of civil law, not criminal law. So criminal law belongs solely to the states. Marriage and divorce. Marriage and divorce is set up by the states. States determine or interpret marriage and divorce differently. Texas has different laws on marriage than, say, Iowa, than, say, Kansas, than, say, Oregon. There's no federal law on marriage. So this is why same-sex marriage is a huge issue for federalism, because states are the ones that are deciding same-sex marriage, not the federal government in any means, just the state governments. And so marriage and divorce is only set up by the state. Now here in Texas we don't allow same-sex marriage, but once again those laboratories of democracy are the ones that are ultimately going to determine what view on marriage ultimately prevails. Education. Education is set up by state governments. State governments are the ones that are responsible for setting up school districts. They're also the ones responsible for setting up the curriculums that students study in school. One example of education specifically would be my home state of Kansas. In my home state of Kansas, we don't teach evolution in schools. I think we're the only state actually that doesn't teach evolution in schools. But that's because Kansas has the power to set its own education curriculum. It's a reserved power to Kansas to set up its own education curriculum. Now this is definitely going to be a hot button issue here in a little bit, education specifically, because education is becoming more standardized, and there's things such as No Child Left Behind and the Common Core program, which are federal initiatives to unify or standardize the education curriculum. But states are kind of stepping up and saying, no, education is our domain. Step away, federal government. Social welfare activities are only to the state. Now, while the federal government may provide the funds for welfare, the states are the ones that are responsible for setting up who gets to engage in or who gets to receive welfare and how much money they get to receive. Police powers, and then also issuing licenses. Issuing licenses is solely set up by the states. You can think about your driver's license, maybe a license to run a business or things like that. Those are issued by the state. There's no federal driver's license, and that's why driver's licenses are so fascinating, as well as I guess license plates as well. They all have their little state logo on them or their own state design, and that's because licenses are only reserved that's a power reserved to the state to issue those licenses. I guess I don't have the local governments yet. That's the next slide. Okay, anyways, so let's go ahead and talk about the state governments specifically. We just talked about the reserve powers that they have. They get those reserve powers from the 10th Amendment. The 10th Amendment is the one that allows the state governments to do anything that is not established by Article 1, Section 8 or the 14th Amendment. The idea of the 10th Amendment really comes from this concept of states' rights groups, that states could declare null and void any federal law that they deem unconstitutional. So the states have the right to deem any federal law that they deem unconstitutional. They can declare it null and void, and they can develop a law that more fits their people. Now it may contradict federal law, and when it goes to a court, the federal law is the one that will hold up. But that being said, as long as it's not super controversial or it's not something that is very high profile, the states can often write these laws because they're the ones that know their people the best, is ultimately what the argument is. The Union is a voluntary compact of states, and so therefore, in order to be a voluntary compact of states, the states need to have certain rights, they need to have certain powers. And if something is unconstitutional, or the state feels that the Union has overstepped its bounds, they can break this voluntary compact. It's voluntary. It's not written into law that states have to be part of the Union. The Union is just there. And that's why you saw states secede during the 1850s, right before the Civil Wars, because they felt that the Union was not going the way they wanted, and so they voluntarily left and tried to form their own confederation, which we all know how that went. But that being said, states can still secede, and there's still strains of secession movements here in the United States today. However, they're not widely popular, and they often don't get the kind of political force behind them. The federal government has no authority to exercise powers not specifically assigned to it, so once again, if they overstep that, the Union is a voluntary compact of states, and states can leave. Any powers not given to the federal government are reserved to the states. That's word for word from the 10th Amendment. This was a huge Civil War issue, but that being said, we kind of settled it in the Civil War that states would be part of the Union. But since 1980s and Reagan's new federalism, it's definitely more popular to be on the favor of states' rights. I'll say that much, because of this term called devolution, which we're going to talk about later on in the lecture. So let's go ahead and talk about local governments just a little bit. Local governments are very unique because they're essential to society, and they're very essential to the structure of federalism. However, they have no status in the Constitution. Local governments are established by state governments and state constitutions. States are the ones that allow local governments to exist. Really, local governments are an administrative arm of the state, and what I mean by that, and what's important for you Texas government students to know, is that they're an administrative arm of the state because they carry out state law regardless of what the state, without the state stepping in. The local governments will look at the state law and enforce it within their local municipalities. Local governments are essential because local governments enforce the state laws, they administrate for the state, but also local governments give certain feedback to the state as well. So there's a level of federalism among state and local governments as well. And local governments are essential to the structure of federalism because local governments give support to the state, and then the state gives support to the national government. Even though the national government doesn't really give recognition to local governments, they understand that local governments are very, very important to the functioning of the United States in general. Now, what's important, I care that both of my classes know this, is the term home rule. And this is really where this is really where local governments get their power. Home rule just basically means that local governments and municipalities can set certain laws and regulations because the state has given them authority. The state looks at these local governments and says, hey, you know what's going on with your people, you know what's best, why don't you go ahead and pass certain laws and regulations, and we'll go ahead and tend to our other business. We have a lot of business going on within the state. You go ahead, you set what's best for your own people because you know what's best for them. You're part of them, right? And so home rule is very, very important. And it's very important, particularly for larger cities, because larger cities have a lot of people to govern, and the state doesn't really want to deal with those larger cities all that much because they have a lot of different tiny other towns. They have a lot going on. And so it's very important for large cities to have home rule, but really all local governments have home rule in some sense. So for purposes of your test, both of your classes, be sure you know what home rule means. And if you have any questions, be sure to send me an email or otherwise. Alright, so let's go ahead and review the types of powers. We talked about each of these three. We talked about express powers, which are powers that are only written for the federal government. We have the concurrent powers, which are powers shared by the federal and state governments. And then we have reserve powers, powers that are only the state government can exercise. The express powers for the federal government only, are the taxing and spending clause, the commerce clause, necessary and proper clause, and the 14th Amendment. Concurrent powers, I won't list them out here, but we talked about a few of them in terms of taxes, building highways, eminent domain, things like that. And then we have reserve powers, powers that only the state government can exercise. And all the reserve powers come from the 10th Amendment because it says powers that are not written in the Constitution are reserved to the states, and that's where the term reserve powers come from. So express powers, federal government only, concurrent powers, federal and state, and then reserve powers, state only. I hope that makes sense. And hopefully that's a good review of the different types of powers. So let's go ahead. We're going to go ahead and talk a lot more about current political issues. We're going to get a lot more into politics, and this is often a lot more fun to discuss with an in-person class. But these are very important issues, and important issues that you're going to face, that you as new voters, young voters, are going to face. And these are issues that deal with federalism. Federalism is at the heart of many political issues, and I hope I can explain this well enough and that it plays out well in today's lecture. So let's go ahead and talk about guns. Guns are always a fun one, particularly here in Texas. We're going to talk about gun regulation. I think we're going to talk about rape and domestic violence, immigration, healthcare, and marijuana legalization. So let's go ahead and first start with guns. Guns and regulation really embodies federalism at its best. Guns are a hot button issue. It's fun to teach in Texas. I first taught this actually in 2012, right after Sandy Hook, and so we had a great debate. Also, I'm going to go ahead and say this right now. If you want to go ahead and set up a discussion board and discuss general political issues online on the course website, feel free to do so. I always welcome debate. Like I said early on in the class, I don't care what your opinion is. I just care that you do have an opinion. That's what's important to me. So let's go ahead and talk about guns. Guns really embodies federalism at its finest, and the reason why is because laws vary across the states. Texas has much different laws on guns because they're a much more conservative state than, say, Illinois, who tends to be a much more liberal-leaning state. And they all have different takes on how guns should be regulated within their state. So laws vary across the state, and it really embodies federalism because there's not an overarching federal law on guns. States are the ones that are ultimately allowed to set its own laws. You have a lot of high-profile incidents that deal with guns. Like I said, Sandy Hook in 2012. I taught this class right after that happened in 2013, and that was it was good to have a good discussion then. It's still important. Guns are still a hot button issue, and a lot of people do take it very personally. So let's go ahead and introduce both sides of the debate. So if you tend to be pro-gun, pro-gun regulation, I should say. If you tend to be pro-gun regulation, you tend to cite that studies show that higher rates of gun ownership means higher rates of gun deaths. That makes sense. More guns, more shots fired, therefore more gun deaths. Which often many people that are pro-regulation will point to and say that we need to regulate guns because these guns are out of control. These guns are causing more gun deaths. People are shooting up people. And if we regulate guns, or if we take away guns in some sort of fashion, or certain types of guns, we can prevent gun deaths in the future. Well, the flip side of that argument, let's say you're pro-gun, tends to be in the voice of the NRA. The NRA is the National Rifle Association. It's one of the largest lobbying groups in the United States. In the NRA, their argument is guns are actually good to have because guns deter people from shooting other people. The NRA argues that you cannot observe a nullified event. So while we do have this high rate of gun deaths, the NRA would argue, how many more gun deaths would we have if there weren't guns? We deter criminals if we know you can deter criminals if they know that you are carrying, or if they know that you're packing heat. They're not going to rob you, and therefore they're not going to rob you, and therefore that prevents a crime. So the NRA will often argue that guns actually prevent crimes and prevent more gun deaths from happening. More guns leads to less gun deaths, and we don't really know how many gun deaths we would have if there weren't guns. And the NRA will often point at statistics such as Chicago, where gun ownership is outlawed, but Chicago continues to have the highest rate of gun deaths. And so that's an argument that's often made in favor of the NRA, or of pro-gun people as well. Whichever side of the debate you're on, I don't really care. That's just kind of the general argument, and I hope I explained both sides well enough. If you don't think I did you justice, feel free to comment in the discussion boards. And like I said, if you want to start a discussion board on gun ownership, feel free to do so. That being said, continually federal judges have struck down lowering the age for gun ownership requirements. So the federal government doesn't really tend to have a trend of supporting gun regulations. However, that being said, in the American public, usually around 80% tend to favor background checks. That tends to be widely agreed upon. Now, there's been many gun regulation court cases, and I want to go ahead and talk about one specifically. And this one really embodies the issue of federalism. And this is United States versus Lopez. And this one really limited federal power and limited specifically the Commerce Clause. Now, United States versus Lopez happened in 1995, and it's a very interesting case because it happened right here in Texas. Lopez was a Texas resident, and he was arrested for carrying a gun to a high school. He was carrying this gun on campus, and this was in clear violation of the Gun-Free School Zones Act of 1990. The Gun-Free School Zones Act of 1990 made it a federal crime to possess firearms in or around 1,000 feet of school grounds, which would make common sense, right? Because you don't want guns on campus, you don't want to cause a school shooting or anything. At this time, 41 states already had bans, but federal laws were a lot tougher on guns. Well, Lopez carries this gun on campus and violates this federal law. Well, he takes it to the Supreme Court saying that the federal government does not have the power to regulate his carrying of a firearm. The reason why is because it did not travel interstate. It stayed within the state of Texas, did not travel interstate, and therefore did not violate the Commerce Clause in any fashion. The issue becomes, can Congress regulate guns that did not travel interstate if there is disruption to the interstate economy? No, the Congress cannot establish this Gun-Free School Zones Act under its powers. There's no substantial economic activity involved here. How is carrying a gun on campus interfering with economic activity in any manner? That's what the Supreme Court really said. You can't argue that his carrying of a gun on campus disrupted the school day, which disrupted the student's education, which made him unable to function in the economy, which disrupted the entire United States economy. That's a blown up argument, is basically what they said. So really the federal government, the United States, failed to show a link to interstate commerce. There's no part of regulation of larger economic activity. Therefore, Lopez is actually justified in carrying his firearm onto a school ground. Now, that being said, state governments have stepped in. States have now said we have the power to. The federal government may not have the power, but now the state governments say that we have the power to regulate guns on campus. And I would definitely bet, I think right now, I'm pretty sure all 50 states have regulations banning guns on campus. But that being said, the federal government can't. The federal government can't do it. The states can. So this is you can see how this is an issue of federalism. This is actually one of the few cases where a regular citizen, Lopez, actually took on the United States government and actually won a lawsuit against them. And he made a decent argument that there's no link to interstate commerce if you carry a gun on campus and it stays within the state. So that being said, United States versus Lopez is very, very important, particularly for gun rights advocates and things like that. But it's also going to be a very interesting debate when we talk about, there's certain talks about allowing guns on Texas college campuses, and there's certain interest groups that are interested in allowing conceal and carry on college campuses here in Texas. So I can guarantee that probably United States versus Lopez is going to be a highly cited case whenever a lawsuit comes against that, or whenever the time just comes to decide whether to allow guns on Texas campuses or not. So let's go ahead and talk a little bit about immigration as well. Immigration is a very important political issue, and particularly for both my federal government students and my Texas government students, I can guarantee this will probably be on your test. And the reason why is because Texas has an interest in immigration, and so this is an interesting case that highlights what Texas can do, as well as all border states. What can they do in terms of immigration? And Arizona was the one to really take the fall for this. Arizona passed Senate Bill 1070, and it sought to do these four things. The Arizona Senate Bill sought to do these four things. One, make it a crime to be present in the United States if you are an undocumented worker or illegal immigrant. 2, criminalize seeking work while not authorized. 3, require state and local officers to verify citizenship and alien status of anyone lawfully arrested and detained. And then 4, allow warrantless arrest of aliens believed to be removable from the United States. Now, this Senate Bill 1070 would allow Arizona to do all four of these things. Now, this was the very first time that a state had taken an immigration issue into its hand. Traditionally, immigration issues had been left to the United States. So the question becomes, do federal immigration laws, are they supreme, or do they preclude Arizona's efforts at law enforcement and preempt the four provisions? So this basically becomes an issue of, does Arizona have the right to do this, or do they not, and the United States is the only one that can do this? The ruling is yes on 1, 2, and 4, and no on 3. And I'll go ahead and clarify this just a little bit with the response. So the federal government is supreme on 1, 2, and 4. The federal government needs to have the authority over immigration, because immigration is between the United States and another nation, not a state of the United States and another nation. So they need to have authority on immigration, and 1, 2, and 4 limit U.S. authority. They impede on U.S. authority. So the U.S. is the only one that can make it a crime to be present in the U.S. The U.S. is the only one that can criminalize seeking work while not authorized. And the U.S. is the only one that can do warrantless arrests of aliens believed to be removable from the United States. Arizona can't do these things. All Arizona can do is number 3, because all Provision 3 does is allow officers to verify identity. They still cannot engage in racial profiling, but it is not a barrier to require persons lawfully detained to show ID. So Arizona, all they can do is require ID of people that are arrested. They cannot actually deport them, or they cannot charge them criminally. They have to turn that over to the U.S. authority. So you can see how immigration is a federalism issue. Traditionally, the United States is the only one that can deal with other nations, not states of the United States such as Arizona or Texas. They can't deal with immigration. They can just turn them over to U.S. authorities if they do happen to capture them in any way. So you can see how immigration is a very issue of federalism, particularly with the border states and here in Texas. Like I said, I can guarantee both of my classes, I can guarantee that this will be on your test for sure. So be sure to remember Arizona versus the U.S. in 2012. Remember, 2012, this is a recent case, so the implications of it are widespread even today here in 2015. All right, so let's go ahead and talk about a more serious issue. We're going to go ahead and talk about rape and domestic violence. This is a very important issue for college campuses, and I would definitely speak to anybody on a college campus. Definitely, if you need services or you need resources, feel free to talk to me. But domestic violence and rape is a very hot topic, and it's a very personal topic as well. So we'll go ahead and talk about this, and we'll see how even domestic violence and rape, even though it's something that happens locally, on a local level and on a state level, it can still very much be a federal issue. This happened in the 1990s, and it went to the Supreme Court finally in 2000. And then there was 2 separate cases. There was U.S. versus Morrison, and then there was Bronskala versus Morrison. The facts behind the case is Bronskala was raped by 2 football players at Virginia Tech. These 2 football players were Morrison and Crawford. They were on scholarship at Virginia Tech, and meanwhile, Bronskala accused them of rape. She sues under the Violence of Women Act. The Violence of Women Act was a federal law passed in 1994, and she sues under the Violence of Women Act, saying that what they did violated this Violence of Women Act. They have this evidence against the defendant, and I'll let you go ahead and read this line here. I won't go ahead and use any explicitives or anything. But the defendant told her this specific line. They have him recorded saying this. It's clear evidence against the defendant. And the defendant tells her this, and they use this evidence. And so the issue really becomes, does Congress have the power to establish the Violence Against Women Act under either the Commerce Clause or the 14th Amendment? The argument was that Congress had the power. The argument in favor of Congress having this power was that Rape and domestic violence is something that's very traumatizing, and it's something that affects all people involved, and so therefore it affects the economy, and therefore it affects commerce in the United States in general. Also, it was argued that they could pass it under the 14th Amendment, Section 5, because Congress has the power to prevent discrimination, and rape and domestic violence is seen as a form of discrimination against women. So therefore, Congress argued that they had that power. Ultimately, though, the Supreme Court comes down in 2003, and you can see it was a 5-4 split decision, so it was a very divided issue, as often these hot topics are. But the Supreme Court ruled that no, Congress does not have the power to pass the Violence Against Women Act. And because of that, Morrison and Crawford both walked free. So they were just alleged of rape. Nothing was ever proven that they actually committed rape. But that being said, the holding here, legally speaking, was that the United States government did not show the link between detriment to commercial activity, and this is exclusively something that is intrastate activity that must be left to the states to regulate. So states are the ones now responsible for regulating domestic violence and rape, and unfortunately the federal government has very little say-so. That being said, Morrison and Crawford walked, and that being said, the federal government still does have statutes in place that define violence against women. The Violence Against Women Act is still around today. Even though it was declared unconstitutional in 2003, I would definitely predict that you're going to see a lawsuit about the Violence Against Women Act, particularly with these most recent high-profile cases of rape on college campuses and things like that. The Violence Against Women Act, as it stands today, it expired in 2011. It was up for reauthorization in 2012. Both parties submitted different versions of the renewed act to include or exclude certain minority groups. The disputed groups were such as LGBT individuals, Native Americans, and undocumented immigrants. It was argued about how these groups should be represented in terms of violence against women, because all of these groups face domestic violence and rape, and so how do we protect them? But that being said, in February 2013, both houses of Congress reauthorized the Violence Against Women Act that included protections for all three of these groups. So now all three of these groups are protected, along with women in general. And now this was in February 2013. You had a split Congress. You had the Republicans in the House and the Democrats in the Senate, and both of them passed this act, which really shows that domestic violence and rape are a very important issue, regardless of political ideology, and a very touching issue, a very personal issue, as it should be. It's a very I'll just say it's a very hot topic, and so having both parties kind of unite under that was a very big moment. Now, domestic violence and rape is a very serious issue, and like I said, there's resources here at Galveston College, and most all college campuses do have resources for those that are victims of domestic violence or rape. So be sure to seek those out if you do need help with that. It's a very touching topic, so I completely understand. All right, so let's go ahead and talk. Let's go ahead and talk about healthcare next. I guess healthcare is a hot button issue, obviously, because the Affordable Care Act or Obamacare, whether you want to call it the Affordable Care Act or Obamacare, I don't really care. It all means the same thing to me. But that being said, the Obamacare and the Affordable Care Act have been it's been a political debate for quite a long time, and whether you're for or against it, whether you have one opinion or the other, let's just go ahead and present the facts behind the Obamacare issue and why it's such a big issue of federalism. All right. So the Obamacare, or the Affordable Care Act, was meant to address the 46 to 50 million Americans that had no health insurance. These 46 to 50 million Americans had no health insurance, but they were still seen as participants or participating in the healthcare market because they would go to the emergency rooms if they needed help, or they would go to see doctors if they had a problem. And they were consuming these healthcare services. but without health insurance, they had no way to pay for them. So the medical industry was in deep trouble because people weren't paying for their insurances. People, and also citizens that were going to seek out these health insurance services, were in debt themselves. And so it was thought at the time that if we could allow everyone to have health insurance, we could allow them to be able to pay for their healthcare services, and therefore it would help out. It would help out the medical industry. It would help out it would help out Congress, or not Congress. It would help out commerce. It would help out commerce, and it would help out the economy in general. Because although someone in Iowa gets sick and doesn't pay for their health insurance, or pay for their medical bill, that affects medical insurance premiums elsewhere in the nation. Or if someone gets sick in Texas and doesn't pay their medical expenses, that affects the cost of health insurance in Iowa. So you kind of get the idea that this health insurance was seen as a national interest. This healthcare market was seen as a national interest. And the Affordable Care Act aimed to try to help that out by making sure that everyone was covered and therefore everyone could pay for healthcare services. The Affordable Care Act set up this minimum coverage here. I know this is quite a text-heavy slide, but the Affordable Care Act set up this minimum coverage by amending the tax code to require individual mandate. This individual mandate said that by 2014, non-exempt individuals who did not have health insurance must pay a tax penalty. So everyone must get this health insurance or pay a tax penalty. The Affordable Care Act also expanded Medicaid, which states had to implement. The Affordable Care Act allowed you to receive federal dollars for Medicaid if you implemented the Affordable Care Act. And the employer mandate there was also an employer mandate to obtain health coverage for employees. So the Affordable Care Act, when it was passed, was hoped that all employees would provide health insurance for their employees. Now, states didn't really like this, or at least these 26 states didn't really like it. And they bring these lawsuits to challenge the Affordable Care Act, and they argue that this individual mandate exceeded Congress's enumerated powers under the Commerce Clause, that Medicaid expansions were coercive. It was trying to force states to enforce a law that they didn't like just to get extra Medicaid dollars, and that the employee mandate impermissibly interfered with state sovereignty, that businesses were part of the state and only responsible to the state, not to the federal government. So this employer mandate they also thought was unconstitutional. So the Affordable Care Act faces lawsuits on several grounds. And these are really the issues that are brought up to the Supreme Court. Issue 1, can Congress pass the Affordable Care Act under the Commerce Clause? Remember, it was argued that it was important to interstate commerce or commercial interests of the United States because these people consuming healthcare services were really influencing the economy in general. And the issue was, can Congress pass the Affordable Care Act under the Commerce Clause power? No. There was no holding that the Affordable Care Act helped out interstate commerce. However, where Obamacare or the Affordable Care Act holds up is, can Congress pass the Affordable Care Act under taxing and spending power? Yes, it can. The Affordable Care Act can be implemented because it is within the power of Congress to tax and spend as it sees fit. And so that's where the Affordable Care Act really holds up. The Affordable Care Act is now upheld because of taxing and spending. Not because of the Commerce Clause, but because of taxing and spending. There is still this other issue. Did Congress exceed its authority when it pressured states and threatened to withhold all federal funding under Medicaid? Yes. Unlike South Dakota versus Dole, where they were just withholding highway funds and playing politics, the Supreme Court really thought that this withholding Medicaid funding was really coercive. Because Medicaid is the single largest grant and aid program, it has the most money, withholding that amount of money is really coercive and forcing the states to do something that they don't want to do. Now, if you want to go ahead and read through these reasonings, feel free to do so. It's very important to kind of know these things, especially if you want to debate with other people, the reason why health insurance is good or bad for the nation as a whole. You can go ahead and read through these reasonings. But for purposes of your test, and I guarantee there will be a test on your will be a question on your test about the Affordable Care Act. Just know that the Affordable Care Act is now lawful, and Obamacare is upheld because of this taxing and spending power of Congress. They can tax and spend, and the individual mandate is not enough. I guess here it is, reasoning 1B here. The individual mandate penalty is a tax, and because it's a tax, the federal government can pass this tax and pass the Affordable Care Act. The penalty is not so severe as to be coercive, and is limited to willful violations like fines for unlawful acts. So if you don't want health insurance, you don't have to have it. It's not being coercive. It's not forcing you to get health insurance. Just know that you're going to have to pay this penalty. And that's where the Supreme Court really held up that the Affordable Care Act was lawful. The note here is that Chief Justice John Roberts is the key swing voter. Roberts is a staunch conservative on the court and was really against Obamacare. But when he looked at it, he said, constitutionally speaking, it is lawful. And so that's where Roberts kind of sided with the liberals of the court, I guess I should say. These tend to be the more liberals of the court. Roberts sided with the more liberals of the court and said, constitutionally speaking, it is legal. And so that's why the Affordable Care Act is upheld today. Now, moving down here onto notes, there's going to be a lot more recent challenges about religious freedom and the Affordable Care Act. What about birth control? What about my rights to seek health care, as certain religions don't seek certain types of health care, such as blood transfusions and things like that. So the debate over the Affordable Care Act is not over by any means, and it's definitely interesting to look at the Supreme Court docket in upcoming years and seeing about the types of lawsuits that are going to happen. We're actually going to skip this next slide, and then we're going to move on to marijuana legalization. So healthcare, we talked about healthcare, we talked about gun regulation, we talked about rape and domestic violence, we talked about immigration. Let's finish off with marijuana legalization. And this is an instant in which marijuana legalization is a very interesting topic, because you have many states that are passing state laws that legalize marijuana, whether medicinally or for recreational use. But those states that are passing those laws to legalize marijuana are in clear violation of federal law. So you have an instance right now where state law is contradicting federal law, and it's going to be very interesting to see how it plays out. But that being said, one of the very first cases that dealt with medicinal marijuana is Gonzalez versus Reich. And for both classes, I can guarantee there's going to be a question about Gonzalez versus Reich on your test. So let's go ahead and look at the facts of Gonzalez versus Reich. In Gonzalez versus Reich, you have Reich and Monson, and they're patients. They're suffering from a medical condition, and they're prescribed medicinal marijuana. And at this time, 15 states have laws allowing medicinal marijuana. So they're within their rights to seek medicinal marijuana because it complies with California's Compassionate Use Act. This Compassionate Use Act allows medicinal marijuana. And so Reich and Monson say, hey, we're not doing anything illegal here. We're complying with California's laws. Well, unfortunately, the U.S. government steps in and says, no, you're not. U.S. government, the federal government, steps in, raids their stash, basically, and brings them up on charges claiming that the Federal Controlled Substances Act, allows federal regulation. Well, the Controlled Substances Act allows regulation and allows the federal government to step in, despite California having it legal. So you can see how this is an issue of federalism. How does the state interpret one law versus how does the state interpret one activity versus how does the federal government interpret the activity? And the issue really becomes, and it goes all the way to the Supreme Court, was the federal raid beyond the scope of Congress's Commerce Clause? Remember, this weed is grown in California, stays in California, and is consumed in California. But the Supreme Court says that the federal government was right in raiding this stash. And the reason why the Supreme Court says this is that Congress can regulate purely interstate activity that is not commercial because failure to regulate homegrown activity undercuts regulation of the illegal interstate market. So basically, if the federal government did not step in and regulate weed or marijuana in this one place, then we could have a problem where it gets distributed and becomes a national problem. Marijuana from California will spread into Nevada, which will spread into Utah, which will spread into Colorado, which will make its way all the way to the East Coast. And so the federal government must regulate in one spot before it becomes a national problem. And so that's why it was seen as a national interest, and that's why the Supreme Court upheld that the federal government could actually raid these people that were abiding by California law. So while it was legal in California, it was still illegal nationally, and the national government was justified because it's a national interest it's a national interest to prevent it before it becomes a national problem. The Controlled Substances Act has the authority to regulate the distribution and possession of medicinal weed because to encourage uniformity among states. Now, that was in 2005. What about now? In November of 2012, we all know that Colorado and Washington voted to legalize recreational use of marijuana, and this was in clear defiance of the Controlled Substances Act. Now, also, in addition to Washington and Colorado, you have Oregon and Alaska who have also legalized recreational use of marijuana. Now, in both states, use of marijuana, also, I guess I should say in all 4 states now, the use of marijuana was to be regulated like alcohol use. Adults over the age of 21 can possess up to 1 ounce and grow up to 6 plants, although I'm not really sure how they enforce that 6 plants rule, because you could probably just grow a 7th and not have anyone know about it. But it's regulated just like alcohol. Now, currently, remember, Gonzales and Reich was in 2005. Currently, you have the Obama administration, and the Obama administration and the Department of Justice has stated that it will allow these states to implement their laws, but it's still going to keep a watch on criminal activities and also distribution to minors. So if you're selling it on a black market or you're selling it to minors, you're going to be kind of punished by the federal government. They're still going to watch that sort of thing. But the federal government's kind of taking a step back. They're saying Colorado and Washington, they passed these laws. Let's see what happened. Let's utilize those laboratories of democracy and see if it actually turns out to be a good thing. And that being said, it's generated a lot of revenue. And so states are kind of looking at Washington and Colorado and saying, hey, there's a lot of revenue to be made here. Maybe we should take a look at this. And so in 2016, you're going to have states like California, and I also believe Nevada, and then Florida, I think also, or they're going to have ballot measures in 2016. So it could add up to 3 more states. It's a very interesting read if you're really passionate about recreational marijuana, or not recreational marijuana use. If you're really passionate about marijuana legalization, read up on what states are up next, and it's going to be a very interesting debate to see how states pick up on what's happening in Washington, Colorado, and to look at the money that's being made there. Now, I usually use this map for an in-person class, so I'll just go ahead and explain it to you right here. The blue states are the ones that are states or countries that have legalized marijuana, and so you have Colorado and Washington here. You can also color in Alaska blue now, and you can also color in Oregon blue here. Then over here you have the Netherlands, or Holland, whatever you want to call it. Amsterdam is the capital of the Netherlands. Amsterdam is often confused for a country, I'm not sure why, but Amsterdam is the capital of the Netherlands, and within the Netherlands it is legal to use recreational marijuana. And then over here I usually have my students try to guess which one this is, but I'll just give it to you now. It's North Korea. North Korea, for whatever reason, has legalized recreational marijuana. I'm not really sure why. They're a brutal dictatorship, and they don't allow their people a lot of things in general, so to allow them recreational marijuana use, very, very interesting. And if you haven't watched the interview yet, I would definitely encourage you to watch the interview. It's on Netflix. It's very, very funny. And actually, and I know it's supposed to be a comedy, but it actually kind of touches a lot on the actual dynamics of North Korea. So, that being said, it's going to be very interesting to see how this map kind of changes, particularly with the orange and decriminalization. Texas actually has a ballot measure to decriminalize marijuana. up for vote in the state legislature next time. So Texas could be orange next, but definitely Texas is a long way from being blue. All right, so we talked about the powers of federalism. We talked about current issues with federalism. Let's go ahead and touch just briefly on the history of federalism. I'm going to go ahead and go a lot. I'm going to go really quickly through this. But that being said, there's still going to be stuff that is on your test that is very, very important. And this is just going to basically cover the timeline and where we're at with federalism up from our founding up until today. So this is the timeline of federalism, and I care that you know this, particularly dual federalism and cooperative federalism. We're going to talk about each of these more in detail. But this is basically the timeline. From 1789 up until 1937, we had a system of dual federalism, and we're going to talk about that, what that means here in a little bit. 1937 to 1960, you had cooperative federalism. 1960 to 1970, you had regulated federalism. And then 1970 up until today, you have what's called new federalism. We're going to go ahead and talk about each of these in much more detail. Let's go ahead and talk about dual federalism versus cooperative federalism. Dual federalism is what's often called layer cake federalism. And what this basically means is that you have a national government on top, and then you have a state government down below. And it's a layer cake. Because you have different levels of government, and they kind of touch and they kind of mix here in the middle, but for the most part the state governments are allowed to do as they wish, and the national government is allowed to do as they wish. They each kind of go about their business. They don't talk to each other a whole lot, they don't coordinate a whole lot, they just carry out the functions that they're assigned. And that lasted for nearly a century and a half, until we got to cooperative federalism over here. And cooperative federalism is called marble cake federalism. There will be a question on your test about which one is called layer cake, which one is called marble cake. So be sure to note the difference between dual federalism, cooperative federalism, layer cake, dual, marble cake, cooperative. And with cooperative federalism, marble cake federalism, you have, instead of having these responsibilities that are separated by national government versus state government, you have now responsibilities that are kind of mixed. You have some national government responsibilities pouring over into the state government. You have some state government responsibilities floating up here into the national government. And all of this, I mean, it's all kind of mixed and mumbo-jumbled, but it ultimately creates a very beautiful cake and a very sustainable system of government. Dual federalism, layer cake federalism, like I said, lasted for nearly a century and a half, from 1789 until 1937. Most of the fundamental powers were shared between the federal and state governments. You had a very narrowly specialized national government. It did a little bit, I mean, it was specialized in what it did, but that being said, it didn't govern a whole lot. It was just kind of there. It was the thing that kind of promoted national stability, more or less. You had states that were doing most of the governing. States were the ones that were experimenting. They were trying out this new nation sort of thing. They were doing a lot of the governing, determining what was best for its people. And the national government was kind of sitting there, kind of overseeing all of it. This federal framework, it provided, like I said, provided for national stability, but it allowed states to operate as they wanted. So if the states did need something, they could go to the federal government. If there was a problem nationally, the national government was there to provide stability and unify the nation. But for the most part, most of the governing was going on within the states. And this lasted for a long time. National government did what it did. State governments did what it did. National government was there kind of in the shadows. State government was the one that was really responsible for the governing. So that was all fine. States were doing a lot of governing. It was efficient. States obviously fought. We fought a civil war during that period as well. States obviously fought, but they felt like they knew what was best for their people. Until 1937, and introduced the idea of cooperative federalism. Sorry, I guess I didn't realize I had this slide in here. Let's go ahead and talk about it just a little bit. This era of dual federalism led to a slow growth. You really had a slow growth because states were conducting their own economy. They were conducting their own sort of governing. And so the states doing their own governing generated slow growth. And also the fact that the national government really couldn't step in and do a whole lot. States were trying to coordinate their economies and try to specialize their own economies, but they didn't really allow the national government to step in terms of interstate commerce. So you had this weak national government. This lasted for over a century, and in the 19th century, federalism really restrained national power. Congress was stopped from trying to regulate the economy. So that's why you had all this slow growth. It's that Congress was stopped from trying to regulate the economy, and any national interference into the workplace was ruled to be unconstitutional. The national government can step in and help out the economy in very many means. And it was the Supreme Court even upheld a lot of this, and that it violated individual state police powers. Supreme Court gave the federal government key powers early on. It gave them the Commerce Clause in Article 1, Section 8. But, like I said, the states were doing most of the governing, and they were really impeded from doing much. Now, that being said, as dual federalism really went on and different interpretations came about, it led to a gradual expansion of the national powers. And you can think about, I don't know how much you know about early 20th century history that much during the 1900s, but you can think about the muckrakers and Teddy Roosevelt and how it then soon became a national interest to interfere in the economy in order to promote standards and livable working conditions for workers, and also better food and a better food source and things. Because it was thought that when you let business kind of go out of control and have no regulation, you're going to get a lot of unsanitary work conditions, a lot of unsanitary foods, and things like that. So that's why this kind of interpretation of the Commerce Clause led to gradual expansion of national power, and that's where we end up with cooperative federalism. As the national government expanded its powers, early on the national government didn't have any power, but then during the 19th century, during the latter 19th century, during the early 20th century, the federal government really expanded its powers, and it ultimately gained the most power during the era of cooperative federalism. And the reason why is because states were kind of running their economies. But then the Great Depression hit, and the Great Depression hit, and it hit states really hard. And the states had nowhere to turn. They couldn't turn to their neighbor states because their neighbor states were broke too. So during the Great Depression, they turned to the national government. And during the Great Depression, they turned to the national government for work programs. And also, they turned to the national government for welfare, such as Social Security and things like that. And the Supreme Court in 1937 issues a series of decisions that laid the groundwork for a stronger federal government and set grounds for the welfare state. If you have taken American history or you know anything about American history, you've probably heard of the New Deal. The New Deal was one that really expanded cooperative federalism. It set up this welfare state in which the national government would set up these work programs to pay workers, and these workers would earn dollars, and then these dollars would be spent in the national economy. It also set up Social Security during this time, and it also set up certain things such as the GI Bill and things like that that helped out workers by allowing the national government to interfere into the economy and interfere into state issues. Now that was cooperative federalism. Now cooperative federalism lasted for quite a long time. And then we got into regulated federalism. Regulated federalism still was cooperative federalism because you had the states and the national government interacting with one another, but they were interacting with one another in a different manner. In the 1960s and 1970s, during regulated federalism, Congress imposes legislation on states and localities requiring them to meet national standards and encourage uniformity. So there was national standards on manufacturing. There had to be a certain length to products. There had to be a certain, I was trying to think of an example, like the auto industry had certain regulations. They had to meet certain safety requirements and things like that. This encouraged uniformity and encouraged the states to act like one another under the national government in order to ensure the safety of all citizens. State and local actions were overridden if they failed to meet these federal requirements. So let's say an education curriculum. If it didn't meet a federal requirement, states were required to undergo a revision process and revise that education curriculum to meet a national standard. So this is really the era of national standards. This is where national standards are introduced. Now these regulations, they impose cost on state and local governments without federal reimbursement. If you didn't meet the national requirement or the national standard, you had to redo it on your own until you met a federal requirement, and then you would receive the federal money to help you out. So there was a lot of cost on state and local governments, and this was kind of unpopular with those that believed in states' rights. And this is where you get new federalism. So People looked at that regulated federalism and said, this is a huge, huge expansion of national government powers. Well, what about the states? Is the national government overshadowing the states? Are we headed towards a unitary system? No, not exactly, because at the time, or because soon after, you have the election of Ronald Reagan, and you have this era of new federalism. And new federalism returns powers to the states. New federalism is this idea, and it's very critical of federal spending programs. It says there's a lack of coordination between national and state governments. And what we need to do is we need to give power to the states. This says that states are the ones that know what's best for their people. And so how the Reagan administration and how the politics of that time comes about is, instead of having regulated federalism, having the national government have this huge power over states, what it says is that let's go ahead and give them the money to do those sorts of things and allow them to determine what's best for them. And this is where general revenue sharing comes in, is with the idea of new federalism. So new federalism gives power back to the states, but it gives them back to the states with some extra money. General revenue sharing, you have unrestricted funds which can be used for any purpose provided by the federal government. Federal government says you can have this money and you can have the power to do with it as you wish, because we are going to restore states' rights, basically. So you have the general revenue sharing, which is this pool of money that states can pull from. You also have categorical grants, which are funds used for narrow specific projects. If you have a narrow specific project that the national government deems necessary, the national government will give these categorical grants and say, you need to use this grant for this purpose. The example here that I have here is the Homeland Security grant. It improves the 9/11 response. I have 911 response. I guess 911 response also. But it was a response to the 9/11 attacks, and this Homeland Security grant says we need to improve Homeland Security, so the federal government gives the states this Homeland Security grant to improve their 9/11 the Homeland Security responses. I'm really unsure if I meant 9/11 or 911, but you get what I mean. Both of them are very important. All right, and then also block grants were also very popular at this time. This block grant was given for general government functions, such as social services, community development. So you have the federal government giving states back the power and giving them the money to exercise that power as well. And that's the idea of new federalism. It returns powers to the states and gives them all this money, all these grants over here. During the Reagan administration, there was a lot of federal cuts, though. Unfortunately, federal government was kind of, because they were so concerned about giving power to the state, the federal government had to make a lot of cuts, and so states had to also raise taxes during this time, which was really wildly unpopular. But that being said, the states were also getting a lot of money for grants and things like that. This kind of shows you how much money really was given to the states. It increased exponentially, and you can definitely see it really took off around here during the era of new federalism during the 1980s. This is where Ronald Reagan takes over for Jimmy Carter, and he increases the federal government grants and aid during his tenure. Where it really takes off is during the Bush administration here in 2000. You have the Bush administration right here that has the 9/11 attack, and so what they need to do is they need to raise grants and aid to the states in order to provide for these Homeland Security grants. Also, you have the increasing cost of Medicare, and the growing number of workers who do not receive health insurance from their employees greatly pushed up government spending on health care. Government was really concerned about these people that were not insured, and so the government needs to cover those costs for those people that are not insured. And what you can see here is we started here in 1950 with the federal government not really giving a lot of money to the state governments, but it increased exponentially, and it's going to continue to grow. And in fact, this was in 2008, and we're almost 8 years from 2008. I'm almost 8 years out of high school. That's crazy. But anyways, I'm sure these numbers are way up here now, and so you have this exponential curve to the grants and aid right here. And so that'll be a question on your test. How has the grants and aid spending increased? And the answer would be exponentially. This slide, there's nothing you need to know for it, so we're going to go ahead and skip that. So this embodiment of new federalism is all about the concept of devolution. We're giving power to the states. We're returning state power. Now, during the 1980s and during this era of new federalism, we've really had a huge wave of supporters that are advocates for states' rights. And states' rights supporters really want this trend of devolution to continue, returning state power. The definition that will be on your test, I can guarantee it, is devolution. Just means giving power back to the states that has been grabbed by the federal government. During the 1930s, 40s, 50s, 60s, and 70s even, we had a huge expansion of federal power, and I showed you that with the era of cooperative and regulated federalism. Well, now now that all that power that was grabbed by the federal government is now going back to the states. I have the example here of the 1996 welfare reform. I won't really get into that, but if you want to go ahead and read those slides, feel free to pause the video and read just a little bit about that. The 1996 welfare reform was definitely one of the biggest pieces of legislation that gave power to the states. It gave them money for welfare and then told them you can use it as you wish for welfare. In modern days, since 2000, federalism has been a major issue for both administrations since 2000. We've only had two presidents since 2000, both President Bush and President Obama. And federalism has continued to be a major issue for them. Even though since 2000 we've had this huge liberal-conservative divide here in America, both liberals and conservatives support the federal government to a certain extent, and therefore support federalism and are really using federalism to advance their causes. So you have liberals on one side. They often want increased public social spending. They want the federal government to spend more money on social welfare programs and entitlements and things like that. But they also want the federal government to promote certain rights and benefits of immigrants, legal and illegal, I should say. The liberals also support federal government supporting global warming and regulation of businesses, like we talked about in the week 1 lecture. Liberals tend to side on the favor of regulation of businesses. But that being said, conservatives also want the federal government to promote their goals. They want the federal government to cut taxes, but also help out with spending on things that are important to them, such as national security and conservative social policy goals. They want the federal government to step in and define traditional marriage, and they also want the federal government to step in and outlaw abortion and things like that. So federalism is very important, whether you're liberal or conservative. Now, I've also noticed in both my classes there's several libertarians and populists as well. And so how libertarians and populists deal with the concept of federalism is going to be essential to the survival of those ideologies and how they use the state and federal government to promote their ideologies as well. So current and future issues that deal with federalism, we kind of already talked a lot about the current issues, but that being said, we also need to think about the future as well. Marijuana legalization, I honestly believe is going to be the hot button issue for the future generations to handle. Marijuana legalization, you've seen 2 states that have successfully generated a lot of revenue from legalized recreational marijuana. How other states look at that, and those laboratories of democracy, how other states look at that, is going to influence how many states actually legalize marijuana in the future. And if enough states legalize marijuana, well, then the federal government has to step in and address it as well. So marijuana legalization is going to be an issue of federalism for sure. And I have the note here, Texas. You would think in a deeply red state such as Texas that marijuana legalization would not be supported. However, this next year in the legislature here in Texas, they're going to vote on decriminalizing marijuana. And so decriminalization is different than legalization in the fact that decriminalization still makes marijuana illegal, but you're not going to go to jail for it. You're just going to pay a fine. That's what decriminalization means. So when you hear about the debate over marijuana legalization, also realize that there's also debate over decriminalization. Tax revenues. Tax revenues are going to be a huge issue for federalism. How does the state raise certain taxes, and how does it sustain its economy through tax revenues and spending and things like that? Education curriculums. I kind of already mentioned this. We have No Child Left Behind, and we have the Common Core program. How do those national initiatives for a standardized education influence the state's sovereignty to determine its own education curriculum? You have this battle between the federal government and the state government over education. Same-sex marriage has traditionally been a state issue, but I believe as you see more states legalize same-sex marriage, you're going to see the federal government step in and have to take a stance on same-sex marriage. Transportation. We're obviously going to need more roads, better infrastructure, and things like that. Whether that's going to be left up to the states or left up to the federal government to deal with will be determined in the future. Abortion laws. Abortion laws have traditionally been left up to the states, even though the federal government has a statute that prohibits states from outlawing abortion. The federal law outlaws states from outlawing abortion. But that being said, the state governments are trying to outlaw abortion for certain trimesters and certain weeks and certain stages of the pregnancy and things like that. So that's a contradiction between federal law and state law. Global warming is going to be impactful whether you're a state or a national government. Global warming is going to impact us all, so how the federal government steps in and tries to promote renewable energy versus how the state's economic interests are at hand is going to be very interesting. And then finally, student debt. I'm actually going to go ahead and play this John Oliver video. I'll play it right after we discuss the discussion boards. Please stick around and watch the John Oliver video after the discussion board questions. And the reason why is because the John Oliver video brings up a very good point. You guys are all college students, and you guys are all going to have to take out student loans. Or you maybe not. If you're that well off, that's wonderful. But that being said, a lot of students do have to take out student loans. So I really want you to watch this John Oliver video, or at least the parts that I showed you. If you want to watch the full video, go ahead. But we're going to go ahead and watch just the parts that talk specifically about student debt. But let's go ahead and we're going to go watch this John Oliver video after I discuss the discussion board questions, because student debt is a very important issue. America now has over $1 trillion in student debt. And how students are going to pay for that is going to be a defining issue in future elections and for future generations, because it's a massive debt problem. And so I think it's very important for you guys to watch, to consider how you guys are going to handle your own student debt. I know me personally, I do have a certain amount of student debt. After watching this John Oliver video, though, I feel very fortunate that I don't have that much student debt. And so it's something to think about, and I think it's very important. Whether you're in college now, or I even have some high school students in this course, it's very important to think about student debt and how that's going to impact your life and your financial future. So let's go ahead and talk about the discussion board questions real quick. Number one, do you believe federalism is important? And what I mean by that, do you believe federalism is important for the United States to function? Is it essential for the United States to function? I want you to kind of discuss hypothetically, could we survive under a confederate or a unitary system? I want you to address both. Could we survive under a confederate system? Could we survive under a unitary system? And when you answer these questions, I want you to consider how the United States fared under the Articles of Confederation. Number two, why do you believe the founders ignored local governments in the Constitution? Local governments are not in the Constitutions, even though local governments are essential to society to function. The local governments support the state governments, support the federal governments. Why do you think the founders just ignored that? Why were they so concerned with states versus the U.S.? Why were they so concerned about states versus the federal government and not the local governments? Consider concepts of home rule and the 10th Amendment when answering. And then finally, the third one is probably going to be my favorite, and I'm really interested in your responses, being most of you being native Texans, me not being a native Texan. But I love Texas severely, and I love Texas more than my home state of Kansas now. That's kind of sad to admit, but I do love Texas. Texas is the only state to once be a sovereign nation. Today, do you think Texas could survive as its own country? Could it do it now? Things to consider when answering. Consider the size of the economy. Texas has a massive economy. Could it survive on its own economy? Consider the infrastructure. Could we survive on our own infrastructure? Do we need those federal grants to support highway systems and things like that? Consider the U.S. grants to Texas. Consider that statistic I gave you earlier, that 20% of state budgets come from the U.S. government. Consider that also in answering your question. Consider the education system, and also consider interstate commerce. Could we establish a new system of interstate commerce? So all three of these questions, please address them, whether you're in my American government or my Texas government course. I believe that all of you have the capacity to answer these. If you're one of the few that are in my American government course and my Texas government course, just go ahead and copy and paste your answers. That's fine with me, and put it on both discussion boards if you could, please. That way I know you answered for both my courses. But let's go ahead and watch this John Oliver video, discussion board questions. Pause the video if you need to. Let's go ahead and watch this John Oliver video, and we'll wrap up this week's lecture.
This week, hundreds of thousands of students started classes at colleges and universities. And one thing is increasingly clear. By the time they graduate, most students are going to be leaving with a lot more than just a tacky polyester robe and a copy of All the Places You'll Go that their tearful aunts got them. They'll be leaving with this.
7 of 10 graduating students left college last year in debt. The total bill due for students in America tops $1 trillion.
That's right. Student debt in the US is now bigger than debt from credit cards and auto loans, and is second only to mortgages. Essentially, student debt is like HPV. If you go to college, you're almost certainly going to get it. And if you do, it will follow you for the rest of your life. Because legally, student debt is a special kind of debt.
It is the most collectible kind of debt there is. It is non-dischargeable in bankruptcy. They will garnish your wages. They will intercept your tax refunds. They will sue you in court.
Well, they won't stop there. They'll steal your wallets, they'll pawn your baby shoes, they will shrink themselves down to 2 inches high, hide in your pocket and take that money back one dime at a time. Student debt has tripled in the past decade. It has surpassed Bob Marley's greatest hits album as the thing seemingly every college student has. How did this happen? Well, more than 90% of student debt is subsidised by the federal government. And it all started with such good intentions. Here is one of the federal student loan programme's early champions.
Poverty must not be a bar to learning, and learning must offer an escape from poverty.
Escape from Poverty. By the way, the single worst Kurt Russell movie ever made. A higher education system open to all was one of LBJ's top priorities, along with creating, of course, a Libyan pool party in Vietnam, and finding a pair of pants that could contain his gigantic testicles. That last one might sound like a joke, but listen to this actual phone conversation that he had in the Oval Office with a representative from the Hagar Clothing Company.
The crotch down where your nuts hang is always a little too tight. So they make enough to give me an inch that I run out there, because they cut me. It's just like riding a wire fence. But you can't leave me about an inch from where the zipper ends round under my back of my bunghole.
We all thought the B in LBJ stood for Baines, but it actually stands for balls, my big bulbous balls are too close to my bunghole. Isn't history fun? But like LBJ's testicles, the federal student loan program is now swollen to uncomfortable proportions. One reason for this might be that in recent years, states have slashed funding for higher education by 23%. Public institutions have responded by raising tuition rates, forcing students to take out ever larger loans. Why else do you think the colleges have so many a cappella groups? They know they sound stupid, they just can't afford instruments anymore. Another consequence of these cuts has been that some community colleges have been forced to reduce capacity, leading to things like a nursing program in North Carolina with a waiting list just to get on the waiting list. Because that is what you need in the land of tobacco and barbecue, a shortage of nurses. But all this shows that people in this country, they want to go to school to better their lives. And it is good that they have broad access to federal funds to help them do that. The problem is, this is where we meet one of the biggest drivers of student debt, for-profit schools.
All right, I'm going to go ahead and skip just a little bit forward. If you want to watch this middle section here on for-profit universities, such as the University of Phoenix, ITT Tech, things like that, it's very, very interesting. It's a very, very, very interesting argument. against for-profit universities as opposed to public universities such as the University of Texas, Texas A&M, UNT, things like that. Public schools are treated very differently than for-profit universities. So if you want to watch this middle part here, feel free to do so. Just look up John Oliver Student Loans on YouTube. You all know how to use YouTube, I assume. But let's go ahead and skip towards the end here on his closing statements.
Bigger than just for-profit schools. If they all went away, student debt problem would still be here, because our leaders have decided that while education is incredibly important, it is not important enough to actually pay for. So, with that in mind, let me speak right now to all current freshmen in college who have student loans. Okay. You need to stop watching this show right now. You don't have time for this. Get out there and enjoy the f*** out of your college experience, because you may be paying for it for the rest of your life. I'm serious. Drink beer from a funnel. Kidnap a mascot. Find out if you're gay or not, and even if you are not, have some gay experiences. Do it now, it doesn't count. Become that weird guy on campus who rides a unicycle from class to class. Find out whoever the Winklevoss twins of your school are and steal their idea for a website, and shoot fireworks out of every bodily orifice you can find. Do it now. Please make sure your college years are the best ones of your life, because thanks to the debt that we are saddling you with, they almost certainly will be. Get up and do it!
All right, like you said, quit listening to me. Go out and enjoy your college years. If you're still in high school, take advantage of those and look forward to your college years. College is a wonderful time. I can definitely say I had a good 4 years of college. I'm going back to school after this year. So, what am I talking about? Anyways, your test is next week. I will post a review lecture next week, and then I'll release the test on Monday. You have the full week to watch the review lecture and take the test until midnight on Friday, until 11:59 p.m. on Friday, technically. So you have all week to watch the review lecture and take the test. It'll be released on Monday. I'm going to randomize the questions so you don't cheat, and also I'm going to look at your submission times. If you guys submit your test at the same time, it's going to look a little bit suspicious as well. So keep all of that in mind and be prepared for the text. Be prepared for the test next week. All right, I'm out of here. Go enjoy your college years.
Our main story tonight concerns something Americans simply can't get enough of: prison. We love to be entertained by it, from Orange is the New Black to seemingly MSNBC's entire weekend programming to the TNT classic Tim Robbins Stands Shirtless in the Rain, the movie.